Good morning, everyone, and welcome to the March 12, 2026 meeting of the Memphis and Shelby County Land Use Control Board. My name is Mary Sharp, and I will be serving as your chairperson today. We will begin this morning's meeting with a roll call. Mr. Ragsdale.
Thank you, Madam Chair. Mr. Gill.
Here.
Ms. O'Connell. Here. Mr. Orgel.
Here.
Mr. Thomas.
Here.
Ms. Wilbanks.
Here.
Mr. Winter.
Here.
Vice Chair Lyles Wallace.
Here.
And Chair Sharp.
Here.
We have a quorum.
Thank you, Mr. Ragsdale. I would like to remind you that copies of today's agenda are located at the front right podium if you need them. If you wish to be a speaker on any case that's on today's agenda, please fill out an attendant speaker's card located at the front podiums. Once you have filled out the card, please bring it up front and hand it to one of our DPD staff members located at the left podium. When that agenda item is called, you will be given an opportunity to speak. At this point, I would like to read our conflict of interest statement. The adopted policy of the Land Use Control Board requires that any member of the board recuse himself or herself from any participation in the discussion or voting on any matter on the meeting's agenda in which he or she may have direct or indirect personal interest. The member shall vacate his or her seat during deliberation on any matter from which they have recused themselves. An abstention may substitute for a recusal for the purposes of maintaining a quorum. I would now like to get approval of our minutes from our last meeting in February. May I have a motion?
Motion to approve the minutes from last month's meeting.
Second.
Okay, we have a motion. We have a second. Is there any discussion amongst our board members? Any discussion? Hearing none, I assume we're ready to vote. All in favor say aye. Aye. Those opposed? Motion carries. At this point, we have some director's remarks by Mr. Ragsdale.
Thank you, Madam Chair. Today, we were wanting to give the board an update on our efforts for our updates to the comprehensive plan, our zoning map, and our zoning code. We gave a similar presentation to the County Commission and City Council a couple of weeks ago, and so I will turn it over to Mr. Nicholas Wardrop to give you an update of where we are and what we will be doing in the next few months.
Thank you. Okay. Thank you, Director Ragsdale, and good morning, board members. We're excited today to take some time at the beginning of today's meeting and give you an update, give you a sort of status of our ongoing effort to update the Memphis 3.0 Comprehensive Plan and, of course, the Unified Development Code. So just in case you're not aware, we are currently 3 years deep into the process of updating 3 documents that are distinct from one another, but they're interrelated and they're, of course, related to land use and zoning. The first, the most general, being the Memphis 3.0 Comprehensive Plan. We are in the midst of a 5-year update. We've been running public meetings since about 2024 on that. And what we've got a little more detail to share with you today about is we're in the process of updating the zoning map for the first time comprehensively in 75 years, and the code text. And I'll share a little bit more about what that looks like and what our timeline is. So first, just to sort of make sure we're on the same page, we're doing a 5-year update to the Memphis 3.0 Comprehensive Plan. That is the big picture. That is the guide. That is, what do I want my neighborhood to look like in 20 years? That's the general sort of vision, right? It is the guide for land use, housing, transportation, so on and so forth. Relevant to today's conversation, that's the document that sets our policy direction for zoning updates and zoning decisions, zoning review, right? And when I say sets the policy direction for zoning updates, that really comes in 2 forms. That is, developer comes to us and asks for a zoning change, but it's also us being proactive and recommending changes on our end, and that's what we're talking about here. The second of the 3 documents is the zoning map. That is what tells you what is and is not allowed in your neighborhood. It divides the city up and the county up into all the various districts. This is the first comprehensive overhaul of the zoning map since 1951. And so that's something we're very excited to, get done. It's overdue. This new zoning map is going to align our map to the comprehensive plan, which we didn't do when we adopted Amendment 3.0 in 2019. We're doing it now. And overall, if there's a one sentence goal here, it's to direct development back to the historic core of our city, and we have a draft map that I hope will do that. Finally, we're talking about the zoning code text. This is, of course, the regulatory document that we usually talk about here. This is, distinct from the Memphis 3.0 guide. This is the regulations. If there is a one-sentence goal for this process, it is simplify. We currently have a UDC that's 542 pages long. We're going to get that down to the 250-page neighborhood. We're going to increase transparency, clarity. It's going to be more obvious for folks, both residents and the development community, what is and is not allowed here. And it's something we're very excited about. The other thing, we have made many, many, many small changes to the code text throughout the years. We have part of it that dates back to the 81 code. We have part of it that comes from 2002, especially in downtown and uptown. We of course have the current UDC, which was adopted in 2011. We're going to collapse all those years and years and decades of changes into one cohesive code text, and we're excited about that. So where are we at right now? We're 3 years into this process. We have been engaging in some sort of public engagement, some sort of work on this since early 2023. In 2024 and 2025, we held 42 public meetings. We met with 1,500 unique Memphians on this process. On top of that, we have done dozens of small group meetings, 2 meeting accounts with neighborhood stakeholders. This is, you send us an email and say, hey, come to our neighborhood association meeting, we'll be there. Like I said, too many of those to count over the last 3 years. What we're excited to sort of beat the drum on today is we have published a first draft of the zoning map. And it's an interactive online format. I'll come back to that at the end. I'll show you what that looks like. We've also published a lot of resources online. We have a comprehensive YouTube tutorial that's sort of aimed at a person who doesn't know what zoning is. We have explainer sheets for each proposed zoning district that give you a one-pager in a nice graphic format. What is allowed? What would the bulk standards be? Those sorts of things. And then we have some specific topic guides. We're going to continue adding more throughout, as we go through this process. And my slide says 50 public comments received. That was true as a week ago. We're now up over 100. So we're very excited about that. And again, we're reviewing those every day. That's become a significant part of my day to day is, reaching out to folks, asking questions, and, trying to really explain what we're doing here and make sure we're getting it right. Going forward, we are going to continue holding public engagement sessions throughout the month of March. We have, I believe, 4 more left scheduled. We're reviewing comments left on the online map. Again, that interactive map I'll show you here in a second allows you to leave a comment on the map itself. That's the best way to make sure we get your comments in writing. We're taking it into account. We are finalizing the draft code text. We have an internal draft that is 90% there. We're putting the finishing touches on it with our legal team and some other folks. We're going to have a public draft in March. So be on the lookout for that. You'll get an email. We will bring all 3 of these items to this body for a vote in this summer. So that's sort of the timeline to give you an understanding of where we see the path forward for these is. Quickly, I'll just go through some of the reasons why this matters. I think, obviously, this body, we're all aware of the importance of land use and zoning. The mayor has set an ambitious goal. We're going to have 10,000 new and renovated homes in our city by 2030. The work we're doing right now will not only allow us to build those, it's going to direct them back to the historic core of our city. It is going to be blunt, direct them further west. And that's, we're going to build up, not out. That's the first line of Memphis 3.0, and that's what we're trying to do here. Our new code, so our current code is very good at reacting. It is very good at, we're going to sit back on our heels, let someone come up with a proposal, and then we'll react. We'll make a decision. It's a maybe code. When someone calls our office and says, can I do this? The answer most of the time is maybe. We're going to move into what is more of a yes and no code. We're going to move into a code where we proactively say, this is the city we want to build. Development community, get on the bus or get off. We're going to make things obvious. We're going to make them clear. And where we have those maybes, sometimes maybe is the right answer. We're going to very specifically, target that, and we'll have a good justification for why we're saying maybe. Finally, our tagline throughout this whole process has been simple, clear direction. We're going to improve administrative efficiency. We're going to get folks answers more quickly because we're going to have a streamlined code. We're going to create more clarity, more predictability, and that's both for the development community and residents. Ambiguity is good for neither. And so we're going to have a code that gives folks clear answers. How can folks get involved, learn more? We got, just 4 more public engagement sessions throughout the month of March. And I'll show those on the screen here in a moment. We've published all those resources I talk about, including the draft zoning map. They're available at 901udcupdate.com. That's the best place to get, any answers, see everything we've published. The best way, of course, is to leave comments directly on the zoning map, the online zoning map. I'm going to show that here in just a moment. Additionally, you can send us an email. The best way to do that is zoning@memphistn.gov, or you can call our main line, 636-6619. So like I said, we scheduled 10 public engagement events throughout the month of March. We've held 6 of those. I'm sorry, just 5 of those. We'll actually be at Frazier Library this Saturday. That's the next thing on the agenda. So hope to see some folks there or at one of our remaining public engagement events throughout the month of March. And finally, before leaving you, I want to show you the map in case you haven't seen it. So here is our draft online zoning map that we published back in mid-February. Of course, each color corresponds to the proposed zoning district. I'll just quickly show you 3 features this map has. One is you can click anywhere. Let's click here, per se. You get what the current zoning is, R6, what we're proposing it go to, residential neighborhood 1. That's a new terminology. We have a staff comment explaining every single one of these changes. There's over 7,000. The cool thing is you're going to ask, well, what's allowed in RN1? If you click Learn More here, it pops up this one-page sheet that shows you what is allowed, what the draft bulk standards are, in, like I said, what I hope is a clear graphic format. The final feature I'll show you is you can leave a comment directly on the map itself. So we can enter an address. I'll just type in some random numbers. 765 North White Station Road, just random. And then you can tell us, it pops up what the proposed zoning is. You can tell us you support it, that you feel a different one is more appropriate, or you're unsure and would like us to reach out. And then you get 1,000 characters here to leave us a comment. And like I said, we're reading every one of these is the best way to make sure we get your comments in writing. So with that, I'll be available for your questions.
Great presentation, Mr. Waldrop. Thank you very much. Do you have any questions? No questions? Okay, thank you. Okay, now we're ready, Mr. Ragsdale, for the Secretary's report and introduction of the procedures.
Thank you, Madam Chair. I do not have a Secretary's report, so I will go into the procedures. At the beginning of today's meeting, we will establish a consent agenda for those items where no one in the audience or on the board is requesting an individual public hearing. After the consent agenda is established and approved, we will move on to the regular agenda. For each case on the regular agenda, the DPD planner will give a presentation. This will be followed by the applicant's presentation and any testimony from others who support the application. The applicant and supporters will be given a total of 10 minutes. Following each speaker, the chair will ask the board members if they have any questions for that speaker. Next, the opposition will be given a total of 10 minutes to present their case. Following each speaker, the chair will ask the board members if they have any questions for that speaker. Finally, the applicant will then have a 3-minute rebuttal period under the same rules. Following all the presentations and after all parties have been heard, the chair will ask the board members if they have any additional questions for anyone who spoke. Then the chair will close the public portion of the case, entertain a motion on the matter, discuss, and then vote on the application. If an applicant or any speaker would like to be heard after the conclusion of the public hearing portion of the case, or if a board member wishes to hear any additional testimony from any party for additional clarification, a motion will need to be made along with the second, and then the 2/3 affirmative vote of the board is required to reopen the public hearing portion of the agenda item. If the public hearing is reopened, both the applicant and the opposition will be allowed an equal amount of time to provide additional testimony. After the additional comments, the board will close the public hearing portion of the case and deliberate and take the final vote. Again, if any member of the audience wishes to provide testimony in support of or in opposition to a case, he or she will need to fill out a speaker's card. These are available at the front podium. Speaker's cards are not required of applicants since their names are already part of the record.
Thank you, Mr. Ragsdale. The board is a supporter of community involvement, and we welcome community comments, neighborhood comments, and feedback. We're respectful of the fact that many of you have taken off work or adjusted your schedules to be here today, but we ask, please, that your comments be made within the time frame allowed. If there are multiple speakers, please try not to be repetitive so as to make the most of your side's 10-minute time allotment. Lastly, I'd like to ask you all to silence your cell phones so as not to interrupt or disturb anyone during today's proceedings. With our proceedings now explained, I would like to introduce to you, to my right, Ms. Lisa Wilbanks, who will be this morning's consent agenda chairperson. Ms. Wilbanks will read items 1 through 14 as the consent agenda. Once the consent agenda is read, if you wish to discuss one of those items individually, please come forward and give us the item number, and we will pull that case. We will then vote on the remaining consent agenda items as one vote, and following the vote, we will hear the cases that were pulled individually. Ms. Wilbanks, will you proceed?
Yes, ma'am. Item number 1, case MJR 2025-032 in Core City. The request is a major modification to PD 2008-325 and MJR 2022-047 to legitimize existing structures located at 363 Mulberry Street. Staff recommendation is hold for 1 month. Item number 3, case Z 2025-007 in Oak Haven and Parkway Village. The request is the rezoning of approximately 18.22 acres in the commercial mixed-use 2 to employment located at 3260 Holmes Road. Staff recommendation is hold for 1 month. Item number 5, case SUP 2026-002 in Oak Haven and Parkway Village. The request is a special use permit to allow vehicle sales in the commercial mixed-use 3 district located at 3568 Lamar Avenue. Staff recommendation is approval with conditions. Item number 6, case PD 2026-001 in Cordova. The request is an amendment to PD 2013-313 to allow a hotel at 0 IKEA Way. Staff recommendation is approval with revisions to the outline plan conditions. Item number 7, case PD 2026-002 in unincorporated Shelby County. The request is an amendment to PD 01-305CC to allow a self-storage mini-storage facility located at 0 Walnut Grove at the southwest corner of Houston Levee and Walnut Grove Road. Staff recommendation is hold for 1 month. Item number 8, case S 2026-003 in Cordova. The request is a 2-lot commercial major re-subdivision located at 5819 Shelby Oaks Drive. Staff recommendation is approval with conditions. Item number 9, case S 2026-005 in the University area. The request is a 3-lot residential major re-subdivision located at 3984 Douglas Avenue. Staff recommendation is approval with conditions. Item number 10, case S 2026-006 in Fraser. The request is a 2-lot commercial major subdivision located at 2315 Dales Avenue. Staff recommendation is approval with conditions. Item number 12, case SUP 2026-005 in the University area. The request is a special use permit to allow a child care center for Leadership Prep Charter School in the residential single-family 6 district located at 4180 Elliston Road. Staff recommendation is approval with conditions. Item number 13, case SUP 2026-006 in Fraser. The request is a special use permit to allow a convenience store with gas pumps in the commercial mixed-use 1 district located at 2999 Overton Crossing Street. Staff recommendation is hold for 1 month. Item number 14, case SUP 2026-007 in Fraser. The request is a special use permit to allow a convenience store with gas pumps in the commercial mixed-use 1 district located at 2627 James Road. Staff recommendation is hold for 1 month, and that is our consent agenda.
Thank you, Ms. Wilbanks. Okay, we have pulled items number 2, 4, and 11. The items on the consent agenda will now be voted on with 1 vote, subject to the recommendation of DPD. If the consent agenda is approved, only items number 2, 4, and 11 will have full independent public hearings. By voting on the consent agenda, each board member is affirming that he or she has read the staff report and agrees with its findings and, where applicable, its recommended conditions. Can I get a motion, please?
Yes, ma'am. Move to approve item number 1, case MJR 2025-032 as a hold. Item number 3, case Z 2025-007 as a hold. Item number 5, case SUP 2026-002. Item number 6, case PD 2026-001. Item number 7, case PD 2026-002 as a hold. Item number 8, case S 2026-003. Item number 9, case S 2026-005. Item number 10, case S 2026-006. Item number 12, case SUP 2026-005. Item number 13, case SUP 2026-006 as a hold. And item number 14, case SUP 2026-007.
Do I hear a second?
Second.
Okay, we have a second. We have a motion on the floor. Is there any discussion? Any discussion? Okay, hearing none, I assume we're ready to vote, and we will do that via roll call.
Thank you, Madam Chair. Mr. Gill?
Yes.
Ms. O'Connell? Yes. Mr. Orgel?
Yes.
Mr. Thomas? Yes. Ms. Wilbanks?
Yes.
Mr. Winter?
Yes, but please let the record reflect that I'm recusing myself from item number 12.
Thank you. And Vice Chair Laws Wallace? Yes. Chair Sharp?
Yes,
Motion carries.
thank you very much. Okay, we're ready to go to our regular agenda with Chair Mr. Gill to my left.
Thank you, Chairwoman Sharp. Item number 2, SUP 2025-035, special use permit to allow a 125-foot monopole cell tower in the residential single-family 10 R10 district located at 170 North Oak Grove Road.
Madam Chair, before we get started, for the record, can you please note that I'll be recusing myself from this issue? I do business with this company, and I want everyone, I have nothing to do with this cell tower, but I do do a lot of business with this company, so I'll be recusing myself.
Okay, thank you. Okay, is the applicant present? If so, would you come up and give us your name and address, and then we will hear the case.
Thank you, Madam Chair. My name is Pat Hahn. I'm the law firm of Baker Donaldson, address 1901 Southern North Birmingham, Alabama. Representing Motion Created and with you here, Pat McElmey, Eisen, over from Sheriff Consultants.
Okay, thank you. We'll hear it first, and then we do have opposition. Okay, thank you. Go ahead.
Good morning. I'm Chloe Christian with DPD, and I'll be presenting this case today. Case number SUP 2025-035, being represented by Baker Donaldson at 170 Oak Grove Road. As you mentioned, the request is to allow a 125-foot cell tower, and this is in Council District 2 and Super District 9. Here's a location map of the property. It's located inside of the I-40 loop in the East Memphis area. We mailed out 143 public notices in December and February of this year. The property is zoned residential single family 10, and the current principal use on the property is a church. So the proposed tower would be located to the rear of said church. The surrounding land uses are predominantly single family with a few institutional uses like the Richland Elementary School nearby. Here are some site photos of the property. Here's the proposed site plan submitted by the applicant, along with an elevation of what the tower would ultimately look like on the right-hand side. You'll notice the access easement proposed to gain access to said tower. And there is some landscaping proposed around the base of the tower as well. These are the submitted elevations of the proposed wood-like vinyl fencing that would be around the base of the tower. So in conclusion, the applicant's proposing to construct a 120-foot cell tower, and staff finds that this request is in compliance with the requirements of paragraph 2.6.2 I1 of the UDC. As was mentioned, the access easement with the gravel drive would require engineering approval. So that is a condition of the request. However, we find that the granting of this SUP will not cause substantial detriment to the public good, nor will it substantially impair the intent and purpose of the UDC. So in conclusion, we recommend approval with the following conditions, and I'll pause for you all to read those conditions. And with that, that concludes my presentation, but I'm happy to answer any questions.
Thank you, Ms. Christian. Any questions? Okay, hearing none, we're ready for the applicant to make your presentation, please.
Thank you, ma'am. We don't have too much more to offer beyond your staff report. We think the staff report that your staff has prepared is very thorough and addresses how our project complies with all aspects of your ordinance. Included in that staff report also were maps from Verizon showing the need for this tower and the need to improve cellular coverage in this area. And as again I noted, we've got folks here to answer questions about that, about the need for the coverage and how this site came to be selected.
Okay, thank you. Okay, any questions of him right now? Okay, we're ready to hear from the opposition. And if you would come up and give us your name and address. And remember, we have 6 and you only have 10 minutes, so try to divide it as much as you can. Opposition, name and address.
And I have these for the board, these exhibits. Good morning. My name is Jonathan Justice, and I live at 5527 Melvin Road, Memphis, Tennessee, in a property immediately adjacent to the proposed tower site. They're passing out packets, but today I only want to focus on one issue as other people will focus on other issues. After reviewing the applicant's plans, I hired a Tennessee licensed surveyor, and his reviewing of the applicant's plan found a material inconsistency. The site plan has 2 different tower locations. One location comes from the dimensioned offsets on the plans, and the other comes from the state plane coordinates listed in the same plan set. Those 2 locations are not the same locations plotted on the ground. Under one of the applicant's own stated locations, the tower is within the required 150-foot separation from my home. This means that the application does not establish a single authoritative tower location, and it does not demonstrate compliance with the setback requirement. The packet I provided includes the license survey and supporting exhibits showing this discrepancy. There's 4 exhibits. They show the survey, They show my home. They show the tower plotted. They also show that the plans show all of our residents based on GIS data, and those are not correct. The footprints are different, as you can see by the license survey. Under the Unified Development Code, the applicant bears the burden of proving compliance. On the record before you today, that burden has not been met, and for that reason, I respectfully ask the board to continue this item until the application provides a corrected, field-surveyed tower location. And lastly, I have two questions. Which of the two tower locations shown in the plans is the applicant actually proposing? The one based on the dimension offsets or the one based on state plane coordinates? And second, does the staff report address the license survey's finding that one of those locations places the tower within the required 150-foot separation from a residence? Thank you.
Thank you. Next, opposition. Opposition. Okay, what is your name?
My name is Arthur Quinn. I live at 5532 Normandy Road, which as the crow flies is about 700 feet directly south of this subject property. But first of all, I'd like everybody in opposition to this application to stand if they would. Thank you. First of all, I'd like to say I'm a retired lawyer, and I know how to be brief, so I will be brief because there are some property owners here that live contiguously with the property, and I think it's important that you hear from them. I have two questions for you at the outset, very simply. Who's the applicant? Your staff report says somebody named Heath McCall. The person that entered into the lease with the purported property owner is an outfit called Celco, DBA Verizon. The people that the attorney who sent in the application says that she represents Towers LLC, or in parentheses, Vertical Bridges. It's important for two reasons. First of all, even in the staff report's recommendation, they impose or recommend that you impose that the cell tower be removed at the cease of operations. I just ask you, who will be obligated to follow that condition? The applicant, the purported owner, and I'll get to that issue in a minute, or someone else, one of these other entities. Nowhere in the file do I see where these entities are explained how they're related. The next question that's very important, who owns this property? The applicant in their application attaches a deed by which the Mid-South Baptist Association conveyed by quitclaim this property to this particular church. In that deed, it reserved a reversionary interest should the church cease to utilize the property. The lease, a memorandum of which is on record in the Shelby County Registrar's office, sets out with specificity what property is being leased for this cell tower, carves it out of this property. Well, the conclusion would be, does that trigger that automatic, and it says in that deed, that quitclaim deed, automatic reversionary interest? There is an argument to that effect. I'm not venturing a legal conclusion as to that, but it's something that ought to be resolved on the front end before you even hear this matter on the merits. Additionally, at the public meeting on this, very simply, which was held on December 19th, representatives of the applicant, whoever that might be, made it clear that the purpose of the cell tower were to improve the services of Verizon in that area, of Verizon and of their customers. There's no proof in this record that this area of Memphis is devoid or is suffering from any kind of detriment as a result of cell tower service. This is solely for the purpose of Verizon. And I don't know why or how they're having problems with their service. Perhaps they were Johnny-come-lately to that particular area. I don't know the answer to that. But by analogy, if this were another industry and our neighborhood already had a McDonald's and already had a Burger King and already had a Five Guys, I don't think Wendy's is automatically required to come in and serve that purpose. And in this case, Wendy's would be Verizon. It's a wonderful neighborhood, absolutely wonderful. This city should be proud of this neighborhood. Right across the street from it is Richland Elementary School and White Station Middle School. Sterling examples of what public education should be in this city. And this 125-foot tower is totally out of sync with this neighborhood. The staff report makes some conclusions, but nowhere in that report does it back up the facts that this would not serve as a detriment to the neighborhood. To the contrary. And if you look at the record in this matter, there were 56 written responses in opposition, 1 in favor. Petitions were filed in here that in opposition of 173 signatures. That's 229 to 1. One response was in favor of this cell tower. And I respectfully submit it deserves more thought and thinking than the conclusory recommendations of the staff report. Thank you.
Okay, thank you. Now, the next 4, you have 3 minutes for all 4 of you.
Good morning. My name is Bianca Lewis, and I live at 5527 Melvin Road, immediately adjacent to the property. After reviewing the staff report, site plan, and the Unified Development Code, I have 2 questions: whether the required code standards were applied to this proposal. First, the staff report states the proposal complies with paragraph 1 of the screening and fencing section of the UDC. However, this paragraph applies to facilities other than CMCS towers. The section that applies specifically to CMCS towers is paragraph 2 of the screening and fencing section. Since this proposal is for a new CMCS tower, could staff confirm whether the application was evaluated under 2.6.2I, paragraph 2? Second, if you look at the site plan, the landscaping is around the tower compound, not along the parcel boundary with adjacent residential properties. The Unified Development Code requires a Class 3 buffer where a parcel containing a telecommunications tower abuts residential zoning. In the location of buffer subsection of the UDC, it requires the buffer to be located along the parcel boundary where the districts meet. That's the property line. Because zoning regulations apply at the parcel level, landscaping around the tower compound would not satisfy the required boundary buffer. So my question is, was the required Class 3 buffer along the residential property line evaluated for this proposal? Because this tower is located immediately adjacent to residential homes, I ask the board to ensure the proposal fully complies with the Unified Development Code before making a decision. Thank you.
Thank you. The last 3 only have 1 minute.
Sorry, I'm Bianca Justice.
Okay, you
I think I
told
said
me.
my
You
name.
gave me your name. Name and address, and you got
yes.
less than a minute.
Yes, good afternoon, members of the Land Control Board. My name is Alexandra Leonard Sinkular. I live at 5471 Rich Road, and I live directly across from the proposed site of this 130-foot cell phone tower. I'm going to speak very quickly. I'm here today to speak in a strong opposition to the special use permit. This proposal is just not a minor change. It is a 130-foot industrial tower at the height of a 12-story building being placed in the center of an older established residential neighborhood surrounded by 2 schools and a playground. It would dominate the skyline, permanently alter the character of our community, and impose significant burdens on the families who live there. This proposal fails the legal criteria of UDC 9.6.9. The Unified Development Code requires special permit use compatible with the neighborhood. not injurious to surrounding properties, not detrimental to public health, safety, or welfare, and in harmony with the intent of the UDC. This tower fails every one of those standards. There's nothing compatible about a 130-foot steel structure towering over single-family homes. There's nothing harmonious about this, about placing industrial installation next to schools and playgrounds. And there is nothing protective of public welfare about forcing an entire neighborhood to bear the visual, financial, and environmental impacts of a tower that did not ask to be built there. It violates our neighborhood covenants. Our covenants clearly strict no more than 2 stories. This tower is equivalent of 12. Allowing a special use permit to override binding covenant undermines the very purpose of having them and sets a dangerous precedent for every neighborhood. It will reduce property values. Some studies have shown that cell towers lose value. Some communities have declines up to 20%. Even conservative estimates show losses between 2.65 and 7.6. For many of us, our home is our largest investment. A 20% loss is not an inconvenience, it is financial harm. It is our retirement savings being erased. It's entirely avoidable.
Okay, your time is up, ma'am.
Can we request another extension for this? Because we have others that would like to speak.
No, we ask you to make sure that your remarks were made within the 10 minutes, and I explained that when I said we had 6 people speaking, you only have 10 minutes. Try to make it in between there, unless the
well, I was told by Chloe that we could request and extend it.
Is that correct, Mr. Ragsdale?
Well, I think Chloe explained what you were just saying. They can request it, and then you guys can, and that's what you were just about to do.
Okay.
Yeah.
Madam Chairman, I would ask that we would extend the time
Okay.
to hear from her.
And how long will we extend it? For 1 minute? We got 2 more people speaking.
Let's give them 3.
3 minutes for the 2 people.
Because she's finishing and then it's only 1 more person.
No, it's 2 more people.
After her, 2 more?
Yes.
Okay, we're
So
fine.
3 minutes and 1.5 minutes per person.
Okay.
Okay.
Thank you, Mr. Thomas.
Thank you.
Organizations such as about the
Okay, yours is complete. We only have 3 minutes for the other 2. Is that correct? Or you want her
I
to
believe
finish?
Mr. Thomas said I could finish. I just have like maybe 30 seconds.
Okay.
Thank you. Okay, there are unreserved health concerns. Organizations such as the American Cancer Society acknowledge that the long-term health effects of our exposure require further study. Area Hub, an environmental risk analysis platform, states that the health effects of RV radiation remains unclear. Given this uncertainty, placing a tower between 2 schools and 2 playgrounds is not irresponsible planning. It is gambling with the well-being of children. This is point 5. This is disrespectful to the taxpayers who live here. Our neighborhood is made of long-standing residents who have invested decades of tax dollars, maintenance, and care into this community. We are not asking for special treatment. We're asking a basic respect for our homes, our property values, our health, and our quality of life. This proposal benefits 1 property owner while shifting all the burden onto dozens of families. This is not equitable, and this is not fair. A simple truth, this tower does not belong in a residential neighborhood. There are appropriate places for cell towers directly across from homes, next to schools, and besides playgrounds is not one of them. This UDC gives you criteria, the facts give you clear evidence, and the residents give you a clear conclusion. My conclusion, for all these reasons, legal, financial, health, and ethical, I respectfully urge you to deny this permit. Thank you.
Thank you. Now, Mr. Ragsdale, when he suggested that we extend it, did all of us need to vote on that?
I didn't hear any objections, so I think we're
Okay.
good.
All right. So you 2 have 2 minutes.
Okay. Good morning. My name is Cheryl Hurst, and I'm at 179 Montello Road. And to begin with, the staff report doesn't reference any of the hundreds or letters of oppositions, nor any of the issues or concerns addressed by many, which have already been addressed today. My property, in fact, my backyard is almost directly adjacent to the proposed site. Although I echo the same concerns of my neighbors, my primary concern as a property owner is stormwater drainage concerns. There is a drainage conveyance and easement, which is directly adjacent to the property in question and behind mine, as well as that of many of my neighbors. This drainage conveyance accumulates significant landscape debris, which is not in itself properly maintained and already affects the proper drainage of stormwater to flow in, thus causing these waters to overflow into adjacent properties, mine being such one. My property, along with 5551 Melvin Road are at the bottom of a hill, and we get most of the runoff stormwaters. In my opposition, I have, and I am today respectfully requesting again that at a minimum, the applicant be required to pay for a civil engineer's report prior to this case being voted on, and that the report provide a drainage and grading plan for the site, specifically addressing how any nearby properties and/or the drainage conveyance and easement may be impacted by the erection of this tower. Thank you.
Thank you. Okay, Ms. Reed, and we'll respectfully give you a minute and a half because I think he really said 5 minutes and I said 3. So, where's Ms. Reed? Amy Reed?
Good morning. My name is Amy Reed, and I live at 5519 Melvin Road. I've lived there for 32 years, and I can't believe that they're going to put this behind my house. Maybe all of my life I've enjoyed this beautiful neighborhood, and it's going to be right out my back door. When I look out my back door, it's going to be right there, literally right there, and it is going to be so close to my house, and it scares me because we have so many children that play there, and they could climb on it. They could do anything. They're all in the church. They play. They enjoy everything that they do over there. They're in the playground that is right next door. They go there and hang out. I'm waiting for their parents to pick them up from school. I've watched them my whole life back there and enjoy everything. And now there's going to be possibly a big giant tower there. And it's just unbelievable. It will just be horrible that it will be there. I can't believe that Verizon or anybody can't decide to put this somewhere else away from all these people that enjoy their houses. We're all trying to maintain our nice neighborhood, and this is just going to put a real damper on everything. And I'm sorry that this is just very upsetting, and I agree with everybody that's spoken before me. I don't know all of the laws and everything about this, but it certainly sounds to me like it's just something that should not be done, and I please ask you to oppose this. Thank you so much.
Thank you. And before we have the rebuttal, do we have any questions of the opposition? Anybody have any questions?
Yes, I want to. Yes. So to the opposition in the neighborhood, I first appreciate you coming down. It means a whole lot to see the neighborhood represented. My question would be, is there anything that, or you had a meeting with the applicant at, I think you all said in December of 25, I'm assuming. Is there anything that they can do that you would accept this cell tower? Or you don't want it, period?
If anyone would want to come up and give an answer.
Yes.
Do you want one person? Okay.
And if anyone has anything different to say, you can also come up.
Do I need to say my name again?
Mr. Justice?
Yes, ma'am.
Okay, we got you.
Yeah, I think from my perspective, my neighbors may agree with me. I think people will feel various ways about the cell phone tower. Ultimately, as the house closest, I want the UDC followed as it's currently written, which means if there's things that are not clearly solidified at this point, then we need to go back to the drawing boards. I'm not trying to stop progress, but the UDC exists for a reason. The reason is, in this case, it's supposed to protect us as residents of Memphis. I think.
Mr. Justice, okay, that's fine.
Okay. Anyone else want to answer his question?
I don't know that that question was answered. Was there anything they could do?
I said follow the UDC.
And I'm assuming your response to that, is it following the UDC?
Yes.
I would just like to ask this board, though, how many of you, though, would like to get up in the morning and look out your front window and
Excuse
see
me,
this?
ma'am. This is a specific question that you're.
The answer would be no. I mean, this thing would be that light flashing would be coming through my bedroom window every morning. So no.
Okay,
Thank you. So I think we got the answer, Madam Chair.
okay.
I have specific codes that it does not follow.
Okay,
Well,
so,
we just were answering his one question.
yes.
As yes
Does
or
it
no.
follow the UDC?
Okay, all right.
No.
No, the question is, is there anything that the applicant could do that anyone would be okay with this cell tower being here?
No.
Okay, thank you. I think, Madam Chair, I think we've got the answer.
Okay, we've got the answer. Thank you. Thank you. Okay, we're ready for the applicant's rebuttal. And you have maybe about 7 minutes because you didn't take your time up to give us a presentation in the beginning.
Thank you. Again, my name is Patton Hahn. I'm here for the applicant. A couple of things. Mr. Justice submitted his survey report. We certainly believe that our survey complied with the UDC and is accurate. However, we'll certainly review. I've never seen the survey that he submitted today. We'll certainly look at it, and if there are issues with our survey, we'd correct it and ensure that it meets the setbacks, because that is the intent of the applicant here. There was some mention of covenants here. We reviewed the title to this property. We're confident that we know who owns it and has the power to lease it. We certainly don't believe that our use of this property would interfere with any restrictive covenants. Regarding property values, I don't think there's any evidence in front of this board that this tower would have any negative impact on property values. Regarding health, Verizon and any other applicant, any other carrier that would locate its antennas on this tower has to comply with FCC guidelines for radio frequency admissions as a condition of their license to broadcast, and believes that this technology is safe. We wouldn't be locating these towers where we do if we did not believe that the technology is safe. They're frequently located on schools themselves. Cobb County, Georgia has a policy of preferring to be located in public parks. It's a safe technology. There was also a concern about drainage. We don't believe that this project would have any negative impact on drainage of this property, but we'll certainly comply with the Unified Development Code's procedures regarding drainage, any drainage studies that are required, and would ensure that this doesn't have a negative impact on drainage.
Okay, did you have someone else that wanted to speak on the applicant side?
No, unless you have questions about the need for this tower or how it was located where it is.
Okay, we have some questions.
So one of the questions or comments just made, one of the ladies just stated a flashing light.
This tower will not be lit.
So there'll be no flashing lights?
Towers that are under 200 feet are not required to be lit by the FAA.
Okay.
Okay, we had another question.
It seems to me that this tower is literally being put in people's backyards, and it also seems that you are a stone's throw from the interstate. So are there not other locations that could be considered that are either more of an industrial or more adjacent to an interstate rather than in, smack in the middle of the neighborhood where there is a lot of opposition and a lot of concern for people's value,
Sure.
Property values?
I'm going to let Mr. McElveen talk about why this tower is being located where it is.
Hey, good morning. My name is Adam McElvin. I'm the RF engineer for Verizon for this area. I reside at 60 Crooked Creek Cove in Oakland, Tennessee. We are actually on the site that is adjacent to the hospital right there near the school at the interstate. The problem is it's not necessarily the site serving the customers. The mobiles still have to talk back to the site. So because of the foliage and the clutter and things of that nature, the sites have to be closer to where the users are. And because of the bandwidth of the spectrum that we use, it doesn't propagate as far for our users to get good speeds on their phone and enable to do all the things that tablets and things of that nature do. So we're up around Sam Cooper and White Station. We're also right there on the interstate, but our objective area was the residential area that is north of Walnut Walnut Grove and around the White Station area, that residential area. And as you can imagine, there's not much out there other than residences. So when this site was brought to me as a candidate for this solution, it checked off most of the boxes to be able to provide the service in those neighborhoods. It's not necessarily serving right there at the tower, it's serving further west in those neighborhoods.
If you look on pages 16 and 17 of the staff report, it has the existing base coverage and shows this proposed location. And then on 17 shows the improvements to coverage west of this proposed and north of this proposed site that Mr. McElveen just discussed. And also shows the existing tower near the interstate at the hospital where Verizon is currently located.
And the green, if you're looking at the map, the green shows the good coverage of each one of those cell towers.
Just to kind of build on that, did you consider other sites before pursuing this one? To address the issues that you just outlined?
Yes, the ones that were brought to me, and Pete can speak to that, but this was the best one. We looked at a lot of different areas, and it was very minimal areas that we could go on due to the dense residential nature of it.
I'm Pete Hilger from Terra Consulting. We were assigned this site by Adam several years ago in an attempt to find additional coverage for this area. Because the area is highly residential, we try to locate outside the periphery. We look at every property that may or may not be available for location of a cell tower. We identified several properties that are north and then along the freeway, only to discover that Verizon is occupying towers very close to that, so that eliminated those. We were also working on a site south of this area along near St. Luke's Catholic Church that also needs cell service, which is part of Adam's mandate. And so we were even looking in the area south to open it up to see if there was more locations that we could put anything. Ultimately, what we had is the school property, City Parks property, and the church. They were the only available parcels of property that could locate. I did, for almost a year, try and reach out to the interim superintendent of schools, the assistant superintendents, facilities directors, with no response from anyone. With regard to the parks, we did have access to the parks and we did speak to the director. And at that time, he was advised that the city has no interest in having or hosting cell towers on city property. That left the church. So that was our only option for getting coverage into this area. So that's...
Okay.
Any questions? Thank you.
Any further questions?
Yes.
From the board? Okay.
And maybe this was addressed earlier, but I may have missed it. Is there a critical need with the existing neighbors? I'm assuming this neighborhood is overwhelming. Verizon is the overwhelming carrier there, and they've complained about their cell coverage in their area.
I don't have a list of all the complaints in our ticketing system, but if you're familiar with Root Metrics, the company that drives and collects data, they have failures in that area, which indicates failures for Verizon customers. We also, from the propagation maps that we provided, showed that the area that we're trying to cover has poor coverage now, and the only way to address that is with a tower. And due to the fact that we can't go higher than 125 feet, you have to have multiple towers in the area, right? So because of the trees and things of that nature, we couldn't get one exactly where we wanted it. This one's a little bit further to the east than I would like it, but it's like Pete said, it was one of the only candidates that, fit the bill, checked most of the boxes. So.
Okay.
Any other questions?
I just have one. Is this a Verizon? I know it was somewhere in this report, but is this a Verizon only or can any other
No,
carriers
it's a
get on it?
multi-tenant.
Multi-tenant,
Yes.
okay.
Any further questions?
The picture you have up there shows where that it has space for other carriers.
Okay, thank you.
I'd like to make a comment on the question she just asked. I've been where this neighborhood is. There's one. I live next door to one that was put there years later, and the company that I was opposing, we actually became friends. But because it's multi-tenant does not mean, just like the one next door to me, I'm with AT&T. And that's been 15 years ago. AT&T is still not on that tower. You know, there's no guarantee that and I don't want to ask another question of these folk here, but just a general thing, are you all with Verizon?
I have Verizon, and I have perfect coverage, and I live in the neighborhood.
And you know, just because we put it there, and I'm sure the church is loving this because they get the revenue from it. You know, if I'd probably be in the same position if I had a church there, but it is. I hope we strongly consider this. That's why I asked the question: was there anything that the applicant could do to get you all's approval? And I'm hearing no. So you know, I understand this circumstance, and you know, perhaps we can. If they said there was something could be done, I was going to ask that we delay this. But if it's a no, a strong no, you know, I just don't see any way I can support this and to side with this neighborhood. And the people have taken their time to come out here, and I understand the Verizon. I'm in the technology business, and I get what you're saying. And I have poor coverage in my area. Since I backed off and allowed them to build a tower, I still get no coverage in my house because AT&T is not there. But other people benefit from it. So I guess I got used to seeing it, so I don't pay it any attention anymore because, you know, I don't walk around looking up. But I fought it hard when it was first coming. And they're necessary evils. But the neighborhood, I know where this neighborhood is, and I just have to side with them. It's because you don't want to look at that. You know, I know they can put the green. You can make them look like, at least the old technology. I don't know if they even do that anymore, to make it look like leaves from or the limbs from trees and all of that. But it still stands out. So, thank you.
Thank you. If there's no further discussion, I'm hearing no further discussion, then we're going to close the public portion of the meeting. We are ready for a motion.
Motion to approve item number 2, SUP 2025-035.
Second.
Okay, we have a motion. We have a second. Is there any further discussion?
Yeah, I just want to say, I think this is a difficult case for us to consider because I do think that the applicant has made a good application. The staff has reviewed it. I know there's some questions about survey discrepancies and UDC guidelines. Obviously, the staff would not have sent this to the board without thorough review. And I'm sure there's some technicalities there that maybe there's some technical differences that there maybe needs some explanation that you can talk to the staff about. But my point is the applicant's made a good application. It's all about technology. We're all about progress. But at the same time, when the neighborhood opposition comes out at this scale, it's overwhelming, and it's difficult to really think through how we as a board can ignore that. And my thought is the applicant really should consider other sites that maybe are not so densely located next to homes. Even the applicant themselves mentioned parks and schools, and I know that you've done some due diligence there, but it's really difficult to agree with a cell tower this close to homes.
Any further discussion?
Yeah, I'd like to say, similar to your thoughts, Michael, while I agree with the applicant, this is very safe technology. There's a tower behind my Madonna School on Poplar in Germantown. But there are probably other sites that might serve this neighborhood better. It's a very densely populated residential neighborhood. I was really hoping that we were going to get away. I mean, I've done some of these cell tower deals. They're great deals. but I was really hoping we're going to get to 5G technology, which is a much lower, less intrusive tower. It can really be hidden around a city. So I'm probably a no on this also.
Yeah, and I appreciate Mr. Thomas's questions too, because I think, it is a good application. And, had there been some lenience or some leeway for the neighborhood to make some adjustments and work come together, I think it's otherwise would have been a go.
Okay, any further discussion? Okay, hearing none, I assume we're ready to vote, and that will be a roll call vote.
Yes, Madam Chair. Mr. Gill?
No.
Ms. O'Connell? Mr. Thomas?
No.
Ms. Wilbanks? Mr. Winter?
No.
Vice Chair Lyles Wallace? And Chair Sharp?
No.
Motion fails.
Motion fails. Next case.
Item number 4, MJR 2026-004, unincorporated Shelby County, major modification to PD 08309CC to modify outline plan conditions and concept plan to align with existing site conditions, remove the existing building elevations from the approved plans and various site improvements located at 6195 Woodstock Cuba Road.
Okay, can you introduce yourself and then we'll hear the case.
Yes, ma'am. Josh Whitehead, 275 Jefferson.
Thank you.
Good morning. Again, Chloe Christian with DPD. I'll be presenting this case. It's a correspondence to PD 2008-309CC, and the case number is MJR 2026-004. Josh Whitehead is here to represent this case, and it's located at 6195 Woodstock Cuba Road. There are pretty much 3 main requests that we're going to consider today. One is to remove existing building elevations from the outline plan. Another is in regards to landscaping. And then the second is to include an existing maintenance building to the outline plan. Here's a location map of the property. As I mentioned, the Big Creek Golf Course PD is what we're looking at today. It was approved back in 2008 by council and commission. There is also an existing enforcement case which is currently in violation for the maintenance shed, which was filed in 2025 March. And again, the 3 main requests today are the landscaping, including that maintenance shed, and taking away the existing elevations from the outline plan. The property is currently zoned conservation agriculture with that PD overlay, and there's a portion in the floodway zoning as well. And the surrounding land uses are predominantly single family and vacant land. Here's the existing Big Creek Golf Course PD. As you can see on the southwest corner along Woodstock Hills Drive, there is a landscape buffer along that frontage, and that will be modified with this request. Pretty much all of the changes are going to be happening in the south eastern corner of the site. Here's some pretty recent site photos of the Woodstock Hills maintenance shed. And then here's some photos from the interior on Miramichi Drive of the cottage building. This is an updated landscaping plan that was submitted by the applicant, showing the various types of pine, cypress, and myrtle trees that would be proposed to sort of screen the maintenance building. As you can see, the updated plan also shows the location of that maintenance shed, and it is located 5 feet away from the southern property line and 108 feet away from Woodstock Hills Drive. I will also mention here, there was an existing access drive and curb cut to the maintenance shed, and this proposal would remove that. So basically, as I mentioned, that southernmost curb cut would be removed with this request. And the maintenance shed, we believe, was constructed between 2010 and 2012, although there were no permits on file for that specific shed, which is why there is an enforcement case. However, we are going to recommend an approval of this request with revisions to the outline plan conditions, which can be found on pages 18 through 20 of the staff report. And that concludes my presentation, but I'm happy to answer any additional questions. Thank you.
Thank you, Ms. Christian. Do we have any questions of her at this time? Okay, we are ready for the presentation.
Thank you, Madam Chair. Josh Whitehead, again, 275 Jefferson. I'm joined with by my colleague Milos Mikic, as well as Cheryl Pardue and Fred Emiston with the golf course. I thought I'd start off with giving a brief history of the site because I think it will illuminate a lot of the issues, the zoning issues with this case. This golf course started in 1965 as the Woodland Hills Country Club. When it was established in 1965, it was a legal use in the zoning district. In 1981, as you may have heard, serving on the board by now, there was a big zoning amendment, a brand new zoning ordinance that took effect in 81. And for whatever reason, I think probably inadvertent, golf courses were not permitted in the AG's zoning district. Now, if we were anywhere else in Tennessee, outside of Memphis and Shelby County, that would not be a big deal because the Tennessee Code Annotated is very generous when it comes to nonconformities. The Memphis and Shelby County Zoning Code is not. The Memphis and Shelby County Zoning Code wants prohibited uses to be frozen and go away at some point. That's why it's so important as we now go through a next big change of zoning. We need to be very careful when we create nonconformities because they are going to be, the intent is for them to be frozen and go away. I just can't believe that that was really the intent of the Land Use Control Board and the City Council and the County Commission in 1981. But here we are, it was downzoned. And so when Justin Timberlake purchased the property in 2008 and wanted to invest $16 million into it, OPD, it was OPD at the time, said, you're a nonconformity, you're supposed to go away, but we realized that probably isn't the case with you, and it was just an accident. But nevertheless, you're gonna have to file a plan development. That is the only way to allow the expansion of a legal nonconformity. And so Mr. Timberlake did, and the issue with that we're experiencing right now is the big catch with a plan development is all of your improvements have to be reflected on a recorded site plan. And it seems like, as we're gonna go over with our presentation, construction code enforcement missed that, Mr. Timberlake missed that, et cetera. Next slide, please. So the issue here is the maintenance shed that is on the recorded plat is in red. The maintenance shed that Mr. Timberlake built is in yellow. The zoning code at the time and the zoning code today says we can move buildings as they are shown on a recorded site plan administratively and have a quick fix, provided the movement is up to 150 feet. If you're over 150 feet, you've got to get the Land Use Control Board's blessing. And so that's what we're here to do. Next slide, please. Going back to building permits, I think what was confounding to both us and DPD staff was this is kind of a campus. There's a lot of buildings strewn throughout the 300 acres. We have permits under 9 different addresses. And it wasn't until last night that I put 2 and 2 together. The electric box for this maintenance shed has a 6005 scribbled on it. And you can see there were some sort of stickers from construction code enforcement underneath that box. Next slide. And indeed, we discovered that 6005 is the maintenance shed. It had several permits issued to it. Next slide. But ultimately, the golden ticket permit, as you may know, is the certificate of occupancy. That's shown on the left side of the screen. And on the right side of the screen, you see all the inspections that it takes to get that golden ticket, which is the certificate of occupancy. Those inspections went from around January of 09 to August of '09. So I wanted to put this on the record. We just discovered it, but we did have a certificate of occupancy that blessed this, next slide, at the time it was built. And this is the 1981 zoning code that was in effect. And the purpose of a certificate of occupancy is to they're required to ensure that the completed structures and the development of property comply with the provisions of this title, the zoning code, any site plans or special approvals for such structures, and any subdivision regulations, as well as the building code. Furthermore, 1623, such certificate shall show that such building or premise or part thereof and the proposed use thereof are in conformity with the provisions of this title. That's why if you have a C of O, it's the one thing that can give you zoning relief. Everybody in this room has a zoning violation. I'm sorry, I do, you do, we all do. But if you have a C of O, it's a great shield until it's not. With that, I'm going to relinquish the floor to Mr. Mikic before we recess
Can I ask one quick question?
Yes, sir.
So are you saying that, I get it on your CO argument and I agree with it, but when they went out to issue the CO, did the inspector for code just not notice that the building had moved 169 feet?
If
per the PD at the time, or is that's back when we had very equal code and planning, and they kind of worked
bingo
two parallel paths, and it wasn't planning over.
I'm going to steal Mr. Ragsdale's thunder. When John Zena became director 5 years ago, one of his many goals was to connect the left hand, the construction code enforcement, and the right hand, OPD, DPD. I mean, they are in the same division. They're separated by 15 miles physically, but what happened, I'm sure, the left hand was issuing permits without fully appreciating the 150-foot rule, or even if they were even aware of the 150-foot rule.
They never even looked. I mean, we went through places. I remember years ago having issues where, we didn't have issues, it was great. They never looked at the recorded PD. They just approved whatever was on site without ever reviewing it. And that's changed today, but.
Mercifully, yes.
Madam Chair, members of the board, Miloš Mikic. So here, I just want to, there's some clarifications in the staff report from the opposition that we wanted to clarify a little bit. So specifically, this is the area when in the staff report, they talk about the Miramichi is violating the subdivision's restrictive covenants. This is the specific area that we're talking about. And the reason that we believe that we're not violating those is the golf course opened for business in 1965, and then the Woodstock Hills subdivision covenants were recorded in 1979. So in that regard, they don't retroactively apply. The other part of it is just the correct venue to discuss that. It's going to be between property owners and civil court. So whether this was approved or denied, it really wouldn't make any determination on those restricted covenants. Next slide, please. So here we've got a 1971 aerial, so it's going to be 6 years after the opening of the golf course. You can see that there has been, at this point already, an ingress-egress route. It appears to be directly for the golf course, as the neighborhood, the subdivision that's been laid out, doesn't have anything built yet. Next slide, please. And here's the 1979 Woodstock Hills subdivision plat. And the reason I have this up is I kind of want to talk about intent. So I believe it's H.S. Mitchell. Yes, the estate of H.S. Mitchell is the one that developed this, and he also developed the golf course. And so when it comes to that intent, it's difficult to understand why the developer would want to create a subdivision and a golf course that are going to violate the covenants, right? That doesn't make... I don't believe that was the intent. And if you see the zoning up there, it's R-TH. I had to look that up. I wasn't around in 1979. That's residential two-family high density. What I pulled up was duplexes. My guess is probably more of a townhouse feel is what they were going to shoot for there to kind of look over the golf course. Chickasaw, Galloway, Memphis Country Club, those are just a couple of the local ones that have that set up. If you've been to other golf courses all around the United States, that's a pretty common setup. Next slide, please. So the road, the ingress-egress route is the other thing I'd like to talk about. As you see at the very top in this OPD at the time staff report from 2008, They talk about how a golf course is a recreational use compatible to those residential uses. And the driveway gets called commercial and things of that nature. But down at the bottom, you can also see Phase 2 of Area B. OPD at the time understood where that road was going to go. It was going to be an egress route. And the very last sentence, the reason why they approved it or were not upset that it was there is they believed that it was going to reduce the existing traffic through the surrounding residential neighborhood. Next slide, please. So here we have that essentially memorialized with this final plan that was recorded in 2009, showing that road. Next slide, please. So back to that 1971 aerial, the last thing that popped up quite a bit that we wanted to clarify was some of the drainage issues. If you go to the next slide, it's kind of hard to see, but this is a lake. And if you can kind of see on the right side, you can tell that there's higher spots. And so to be overly reductionist about drainage, which can be very complicated, as water is going to move from some of those higher spots to the lower spots. And you can see in this picture that that is kind of a natural resting place for this water. And then you can see the subdivision is planned out to be built directly over that water or on the banks of it. Here we have, this is actually really cool. It is LEED certified, GEO certified, and Audubon certified. It's the only golf course in North America that has that distinction. If you're not familiar with LEED and GEO and Audubon, they're very environmentally friendly organizations that really run that home. And so I just wanted to point out that, this isn't unmanaged land. It's one of the most environmentally regulated golf courses in the United States. And it appears to be the most certified golf course in regards to that. So again, that golf course is already in a natural drainage basin, and they've done a beautiful job of building that. And so we just wanted to point out that we don't believe these drainage issues are a result of the golf course, but in fact, that it's a wetland. And it was kind of there before that. And so I just wanted to kind of show that picture, give a little bit more of the history of what it looked like before these buildings got put there. And with that, if you guys have any questions.
Just a quick question. Is the golf course still operating?
Yes.
Today, it's a public golf. It's not, you can just go and pay and play.
Yes.
All right.
Any other questions right now? Okay, thank you. We will hear the opposition. Whit Sutton. Please give us your name and address.
Good morning. My name is Whit Sutton, and I live at 6034 Woodstock Hills Drive. I also have property at 6028 Woodstock Hills Drive, which is right next door. I'm here today to urge you to deny major modification MJR 004 for several issues, and I want to speak to these issues one by one. The first is the issues of as-built conditions. What is being presented here today is a simple request to reconcile as-built conditions. In reality, is a request to retroactively legalize a history of unpermitted development. The structure that was just built was never approved on the original 2008 plan development. It began as an unpermitted temporary fabric building that was placed there during golf course construction, for golf course construction. It was never removed. And it collapsed during a storm because it was completely neglected. It was falling apart. After it collapsed, they let it sit there for almost a year and reconstructed this fabric building with steel panels on a frame that was designed for fabric. This was done without a single permit, without an engineering review, without code enforcement oversight. We're looking at a structure that is uncertified and potentially unstable. This structure is directly across the street, rock's throw from my house. Zoning and covenant violations. This maintenance yard sits on land that is zoned for residential use, RU2. Unlike the plan that was shown on there, Josh showed, there was a revision to that 2008 plan that removed that maintenance facility in 2009. That wasn't shown. The real maintenance facility sits on Woodstock Cuba Road that they completely abandoned. It's a perfectly good facility, but they abandoned that for convenience. The covenants are clear. These lots are for residential use only, and they explicitly prohibit offensive trade or activity, nuisance to the neighborhood. An industrial maintenance yard in the middle of a residential cul-de-sac is a definition of a nuisance. The use of residential property for Miramichi's commercial gain is common because a main entrance and 90% of the drives sit on residential property. The same property they're trying to add to the planned development to get you guys to vote on, this property is also governed by our covenants. Operation, impact, and neglect. For a year, my neighbors and I have been subjected to industrial scale noise. We are woken as early as 4 a.m. with tractors, loaders, and heavy equipment. This goes on 7 days a week. We deal with dust, unpaved lots, close proximity to fuel stations, and pesticide operations. The applicant claims we're offering corrective actions, yet they have failed to provide a landscape plan that meets the Class 3 buffer standards required by Shelby County UDC Section 4-6-5. This requirement is mandatory for industrial facilities abutting a residential area. Now, one other thing, we have a history of bad faith. On a personal note, I've tried to work with these folks. I value the course, I value the employees. I've asked for only 3 concessions, 3, to support this application. 1, the removal of the unpermitted curb cut. 2, removal of the industrial fan pointed at my house. Sounds like a helicopter. And 3, they install the UDC compliant landscaping. While I initially agreed to the first 2, they refused the landscaping requirements. And let me tell you, this is particularly egregious to me because I donated 9 trees to plant in that area with permission to the golf course. When the owner let the grass in the neighborhood grow up to chest high, I called Shelby County Health Control, Vector Control, to try to get them to do something about it. We had snakes, we had rats, we had fire ants. The owner, when he found out, destroyed those trees. In conclusion, the golf course moved these operations from an isolated facility on Woodstock-Cuba Road. It's there now, perfectly good, for their convenience. That convenience has come at a direct expense to the property values of our homes and the quality of my life. You cannot modify a facility that was never legal to begin with. I ask you hold this owner in the same standards as any other developer and deny this application. Thank you.
Thank you, Mr. Sutton. Do we have any questions of Mr. Sutton? Board members? Okay, thank you. We're ready for the rebuttal.
Madam Chair, I think there was another speaker that, I don't know if you got the card.
I didn't.
Okay.
Okay, I'm sorry.
And I apologize. Can we get, yeah.
James Higgins, 6146 Woodstock Hills Drive. The owner owns 9 pieces of property in that residential community. I appreciate them pointing out the 1981 registration of the paperwork into the county. In that, where the covenants were placed there on the original subdivision, it was by the original owner of the golf course. There was no mistake by Ms. Mitchell in what they did for the covenants. They were very specific to ensure those pieces of property would be for residential use only. Where the new maintenance facility is proposed is one of those pieces, and the large piece that he showed is another one of those pieces. Those cannot be modified. Property rights and those covenants have been litigated, although not just ours, but in general in the state, have been litigated with land use boards all the way up to the state Supreme Court, and they have ruled whether zoning or covenants, whichever is more restrictive, governs the other pieces of property. They cannot be modified. The only way to modify it is a very specific legal process. It starts with our community and the homeowners and property owners. Then it can come back after a vote has been done, whichever way it goes, whether they vote for it or not. Then we can ask for the modifications. It can go to a court. Then it can be moved back to this board. I didn't make those processes. Whoever did it originally may not have understood it. Ms. Mitchell did. That's why she was very specific in this. The amount of violations and code violations
by the golf course, and they talked about drainage. Across from 6146, as recent as Friday, they were dumping more debris off of the road into the drainage ditch to block it. We already have issues with that flowing up over our property and washing out the driveway. On Fairway 12, they went in and have purposely filled in the box drain, preventing the stormwater runoff from going under the road where it's supposed to. You don't reward people who have a history and a track record of violating codes and regulations, and then allow them to come back and only give you part of the story. The community wasn't even notified of this. We understand things were mailed out. There was no time for those people to show up because many of the actual landowners live out of state. We have 9 in play, 9 pieces of property, and we only received 2 notices. Where are the other 7? The community has to be notified to be able to come. Many people submitted their opposition. Simple things, fences. They don't even care about road restrictions and road setbacks, let alone drainage that they specify in their own PD, and then they violate it anyhow, and now they come back before the board and ask to vacate their current PD, and they're hiding it under the guise of a modification. It is not. It's trying to vacate the existing PD and saying, oh, well, we want to make it the way that we are operating right now without telling you about all of the other buildings that are there. They call a private driveway, but it's a road, and it's a commercial road through those restricted residential lots, and it specifically says Miramichi. Our community agrees that it would be good for these things to come under the PD so that there's teeth that can be enforced. But at this time, till these things follow the proper process, we respectfully request that the board reject and deny this modification and vacate. Thank you very much.
Thank you. Do you have any questions?
I do. Can someone from the opposition address the covenants question? Is this lot that's in question, is this lot in the plat that is covered by the covenant?
According to the 1981, property that was put in, that they showed as part of this by Miss Mitchell, yes, 2 of them are. They only highlighted 1 of them. The other one is where the maintenance facility is at the very end. And those 2 are absolutely in there. There's 53 total lots in that subdivision. Those are 2 of them. And the owner actually has 2 votes in what gets said.
Well, the reason I'm asking is because on the page 104 of the staff report, it looks like it shows the plat for the neighborhood, and to me, it looks like the piece where the building is, this maintenance building, is not included.
If you look at the 1998, or 1981, excuse me, it is. That is one of the 53 lots highlighted by Miss Mitchell on what they showed up there.
Okay, well, perhaps the applicant can address that as their burden of proof.
And Madam Chair, if I may also just to clarify, we do not enforce restrictive covenants, so that is a private legal matter, just to make that clear as well.
Sure, I'm just trying to address neighborhood questions. That's a good point.
Okay, thank you. We'll now have the rebuttal from the applicant, and he can address.
Thank you, Madam Chair. And to reiterate, Mr. Ragsdale, there's a lot of legal concepts surrounding restrictive covenants and as to whether they have been abandoned through acquiescence, as to whether uses that pre-existed the subdivision in question. So the courts actually caution planning commissions, and in this case, Land Use Control Board, from attempting to let a restrictive covenant argument interfere in their judgment, because then that puts the city and the county into a contract that it is not a party to, right? The restricted covenants are contracts between different property owners. But yes, you can't be in a subdivision and in a planned development. So the maintenance shed is fully within the PD. The drive is within lot, I think it's 52 in question. But I guess there would be a question, is a drive that serves a recreational use a commercial use? But that, again, is a question for Chancery Court. Next slide, please, Mr. Mikic. And one last point I wanted to make with regard to the comments. The recent flood that happened earlier this week, our team were removing debris from the curb, and we were actually stopped from doing that by the last gentleman who spoke. The other outlet, we make every effort to clean out these outlets. It's a public drainage easement. And finally, we are not an industrial use. We are a recreational use, and we are required to have that buffer that's on the screen and not a Class 3 buffer. A Class 3 buffer requires site-proof fencing, bushes, and trees. Next slide. And yes, this was the permitted with a certificate of occupancy structure. It was destroyed, and its roof at least was destroyed in a 2023 storm. Next slide. We rebuilt it in the exact same location. We did no structural or foundational work with this proposal. We had MLGW help us reconnect the electricity, and I realized that maybe some of us, particularly in the dais, know better, but when a layperson hears from MLGW, you don't have to get a permit to do that work. Many lay people believe that MLGW, which is a City of Memphis spokesperson, is speaking on behalf of the city, construction code enforcement, et cetera. So we did not circumvent the process on purpose. We just didn't know that we needed a permit to rebuild this permitted structure. And by the way, here's the stack of permits that we've obtained since 1999, right? Permits don't go before 1999 on our online website. Next slide. And here's the shed, the maintenance shed today. And you can see that we have, outside of the right-of-way, replanted some trees. And that's really what we're trying to do here today. We realize that this building is 169 feet closer to Woodstock Hills than it should have been. And Mr. Timberlake, again, did not build it where he should have. As Ms. Christian mentioned, we are going to remove that curb cut, that drive from Woodstock Hills. Next slide. And more importantly, replace that existing landscaping plan that required 13 red maples and replace it with much more evergreen variety, totaling 52 specimens. So we're going from 13 to 52. Next slide. And this is an image I think Ms. Christian already showed. We're trying to take that 13, not only bump it up to 52, but then really concentrate it in the area. We appreciate the fact that 169 feet is a lot, right? And that we're much further east than we should have been, thanks to a permit issued, it may be in error back in 2009. So that's why we're clumping as many trees, again, many of them evergreen, as possible near that maintenance shed. Next slide. Next slide. This is just a close-up. Next slide. Next slide. And I wanted to, this is a maintenance shed I don't live too far from that's operated by the city. It has many more outdoor components to it. It is about the same distance from the street, Galloway Drive, 100 feet versus our 108 feet. Next slide. And this just shows what a buffer can do, a buffer of landscaping, evergreen, and deciduous trees can do. Next slide. This is just looking another way. And you can see, in my opinion, I don't think there's been any adverse effect of that maintenance shed. This serves Galloway Golf Course to the people on West Galloway Drive. Next slide. And then finally, I think it's not articulated in the UDC, but I think Mr. Ragsdale would agree that when the Land Use Control Board is making a decision on a major modification to a PD, really what it's being asked to do is determine whether the original findings that you made in 2009 are intact. And here's a summary of those first three approval criteria. This project will not have a substantial or undue adverse effect on the surroundings. It'll be constructed, arranged, and operated to be compatible, and it's adequately served by public facilities. One last point on the fan. We have disconnected the fan, so it's only going to be operated. This is the fan in the maintenance shed that was mentioned by Mr. Sutton. We've disconnected it, so it'll only be operational in the summer months, but we did turn it on, Ms. Pardue, and at the property line, at our property line, it produced 48 decibels. Next slide. And 48 decibels, if you Google 48 decibels, Google says it's a quiet, moderate sound, roughly equivalent to a quiet suburb or a quiet office. With that, Madam Chair, I'm available for any questions.
Thank you very much. Do you have any questions of Mr. Whitehead at this time?
Just to clarify, so I think I was going to ask about the things that the first gentleman spoke about. You've addressed all those. You've addressed the sound, the landscaping, and there was a third. I forgot what it was. But anyway, just to summarize, this shed was allowed by right in the PD. It's just in a slightly different spot, right?
Yes, sir.
Okay, thanks.
Anybody else? Okay, hearing none, we're going to close the public portion of this meeting and present a motion.
Motion to approve item number 4, MJR 2026-004.
Okay, we have a motion. We have a second. Is there any discussion amongst our board members? Is there any discussion?
I'll just say this. I understand the neighbor's point of view. I looked at, Mr. Sutton is directly affected by the shed across the street, but I think that the applicant has tried to do a very good job of addressing each one of their issues. So I'll be for it.
Okay, anybody else? Okay, without any further discussion, I assume we're ready to vote, and we'll vote individually.
Thank you, Madam Chair. Mr. Winter?
Yes.
Mr. Orgel?
Yes.
Ms. O'Connell? Yes. Mr. Thomas?
Yes.
Ms. Wilbanks?
Yes.
Mr. Gill?
Yes.
Vice Chair Dawes Wallace?
Yes.
Chair Sharp?
Yes.
Motion carries.
Motion carries. Thank you. We're ready to present number 11.
Item number 11, SUP 2026-003, Fraser, special use permit to allow a drive-through restaurant in the commercial mixed-use 1, CMU1 district, located at 2342 Fraser Boulevard.
Okay, is the applicant present? If so, come and give us your name and address, and then we'll have staff present your case.
My name is Sonny Chow. I reside at 3990, Potterwoods Cove.
Thank you.
My name is Alexis Longstreet, and I'll be presenting on case SUP 2026-003, located at 2342 Fraser Boulevard. This application is for a drive-through restaurant. This property is located in the North Memphis area. Were 120 notices that were mailed out February 20th, 2026. This property has a commercial mixed-use 1 zoning district in which drive-through restaurants are not permitted by right, which is why the special use permit is before you today. The property has a land use designation of commercial. Here are some site photos here. This property was an existing Pizza Hut since the 1980s, and probably at some point between then and more recently, it did cease operation. The applicant then utilized what was also the pickup window to establish a drive-through window in this area. So although there was never an actual drive-through established, it did have the setup for the pickup window to be there. And here is a proposed site plan. We do have some conditions placed on this, although we are recommending rejection due to the use itself and as well as the Memphis 3.0 goals for this area. And so, as I mentioned, it is inconsistent as well with the Memphis 3.0, and we do have Memphis 3.0 staff here as well to give a little better explanation as to the goals for the area and the intensity of the proposed use. And as I mentioned, here are those conclusions of the existing Pizza Hut, which was a dine-in restaurant with a pickup window only, not servicing drive-through customers, and as well as those conditions in terms of having the front facade with the minimum transparency of 40%, paved area along the principal structure and sidewalk to ensue for streetscape landscaping, as well as a Class 3 buffer for the residential properties that are abutted north of their residential zoning district that abut the business along Fraser. And at this point, I will introduce Christina.
Hello, my name is Christina Edinburgh. I'm of the Division of Planning and Development in the Office of Comprehensive Planning, also known as the Memphis 3.0 people. I am here to talk about the inconsistent status of this particular development site. So first of all, just as a reminder, Memphis 3.0 is the big vision. It's the long-range plan where we want to move in the future. It is the guide, not the individual parcel-by-parcel rules. So the big picture for Fraser Boulevard in particular, this site sits between two Memphis 3.0 anchors, one at Fraser Boulevard and University and Fraser Boulevard and Rangeline Road. The goal of the big picture is to have a new Fraser Boulevard that is more walkable, that is more connected, and it's more neighborhood serving. So I want to be very specific that the inconsistency is not the restaurant. The restaurant is 100% consistent. What's inconsistent is the use of a drive-through in a place that the long-range vision is to make walkable. The other thing is, as a long-range vision is to make Fraser Boulevard more walkable, we, as the city has started to invest through Accelerate Memphis, money at each of the anchors with a bike lane in order to promote walkability, like already in front of it. So a drive-through would interrupt what's already there. There are some existing drive-throughs on Fraser Boulevard already, but they all exist before Memphis 3.0 was adopted. I do believe that is all of my notes, but I am also here to answer more questions. Thank you.
And that concludes the presentation.
Okay, thank you. Any questions of staff at this time? Ms. Longstreet? Okay, we're ready for you to make your presentation.
Thank you for speaking to all of those points. I do want to mention, I think you at some point mentioned that the Pizza Hut did have a drive-through window but never utilized it, but that is indeed, I think, false, because during COVID times when the inside of the building, you could not actually go inside. The doors were locked. They had plywood already put up and everything. And the only way to actually order pizza from that Pizza Hut was through that drive-through window. So there was no way for a customer to go in, walk in, and sit down and eat. So in theory, as when we took over the place to modify the building, we should be able to be grandfathered in with that drive-through system and be allowed to have a drive-through system. For walkability, we have submitted, and especially the barrier, we have submitted already a new site plan with a barrier, with foliage, and I think at some point, I guess that never just got through. So we'll have to get that resubmitted, so we'll get that all approved and everything. But after that, I think everything should be good. Anything else along these conditions as well, we'll make sure those are met as well, and we'll make sure, and I don't know what else to say, but I feel like we should be allowed to have a drive-through system as we should be grandfathered in.
Okay. Any questions of the applicant? Okay. Go ahead, Ms. Longstreet.
Okay. This case does also have to go before City Council for final approval as well.
Yeah, we do. Okay. All right. I'm going to close the public portion of this meeting, and we're ready for a motion.
Sure thing. Item number, motion to approve, item number 11, SUP 2026-003.
Okay. Is there any discussion? Is there any discussion?
I have a little bit. I do like the aspirations of 3.0. I mean, I'm looking at Fraser Boulevard. It's a 5-lane road. It's probably 100 feet wide with a constant turn in the middle. It's a big right-of-way. It's hard. I know we want to make Shelby County walkable. I get it. But we have enormous right-of-ways. Nobody wants to walk on a 100-foot wide right-of-way. I just struggle with this a lot. As a developer and as a planning commissioner, it is something that I aspirationally want, but also in reality know that no one here walks anywhere. So to deny him from having a drive-through to me is crazy in a way, especially when, I sold that Tops Barbecue down the street and to a group out of California, and it has a drive-through and it's a block away. So I struggle with this, denying him the drive-through use but I understand the aspirations of 3.0 and wanting to see those happen also. I just don't think we can change people's behavior, and I don't think we're going to dramatically create friction, add friction to a 100-foot wide right-of-way that's 5 lanes wide. So I don't know where y'all stand on that, but I'd love to know what y'all's opinion is.
I absolutely agree with what you're saying, 100%. As an aspirational, but I can't see this becoming, a pedestrian thoroughfare. So, and to take away from business for that reason, I think is problematic to developing this as a viable corridor for business. So I agree with you.
We got a motion, right?
We have a motion, so you can vote anytime you want.
Okay. All right, we're through with our discussion, and so I assume we're ready to vote. We'll do it individually.
Thank you, Madam Chair. Mr. Winter?
No.
Mr. Thomas?